Michigan judge is now rejecting guidance from Jocelyn Benson. The 2024 presidential election will be a chance for us Americans to define who we are and who we strive to be. Now and for years to come, we will rise above the noise and endorse truth, freedom, and decency, or will we allow the forces that divide us with misinformation and chaos to rule the day? The order came out from Jocelyn Benson in 2020. You guys do it this way. Accept everything that comes in. Republicans sue. It's not until March 2021 that it's over. A major court ruling now putting a halt to some attempted election rigging by this woman, Jocelyn Benson, who we remember from 2020, where she put her handiwork on that one. There in the state of Michigan, she has a big problem with Donald Trump, TDS level 10 plus at least, and she's been working as the Secretary of State to interfere, in my opinion, with the normal operation of a legitimate election. She said this on X very recently, says, you know, the 2024 presidential election will be a chance for us Americans to define who we are and who we strive to be. Now and for years to come, we will rise above the noise and endorse truth, freedom, and decency, or will we allow the forces that divide us with misinformation and chaos to rule the day? She's responding to Matthew Dowd. He says, this vote this November is fundamentally not about the character, the values, and the integrity of Trump and the GOP. It's a referendum on our own character, our values, and our integrity, and citizens of this once great democracy. I don't even know what they're saying, to be honest. What are they talking about? Who knows? But all they know is they just want to win. And if you challenge them, it's misinformation. So what is Jocelyn Benson doing? Now, we've been following her for a long time. If you joined us in 2020 when we were covering all of that election litigation back then, we heard a lot about her, and she's up to no good again. And Michigan went in the Democrats' favor, allegedly. So here's the story over from a Michigan news source. Michigan judge is now rejecting guidance from Jocelyn Benson. They said that clerks who look at signatures on ballots, when they come in, they should initially presume that the absentee ballot signatures are valid. There's a presumption of validity, meaning you don't challenge it. You don't even check it. You just presume it's valid unless it's clearly not. Rather than saying, are these equal? Let me make a distinction. Okay, there's a higher level of scrutiny. The judge did uphold separate rules that give clerks broad discretion on why they may not match, but a 2023 election law helped save Benson's 2022 rule that detailed how clerks can compare signatures. So this is not just about 2024, 2022, 2023. The court gives us background on 2020 and how this presumption of validity existed back then. The 10-page order from Christopher Yates struck down that guidance, a victory for the Republicans who sued. But Yates, an appointee of Governor Gretchen Whitmer, preserved other state rules that still give them broad discretion to accept signatures that don't exactly match. But it's not the presumption of validity, which is wild that this is something that is happening in Michigan. So here's the opinion. Republican National Committee sued Jocelyn Benson. She's the Secretary of State of Michigan, someone we covered a lot during the rigging of Michigan in 2020, who's now trying to do it again until the judge Christopher Yates put a halt on this. Here's the opinion from the court saying, all right, look, the dispute before the court is not only the latest chapter in a long battle over presumptions of validity of voters' signatures on absentee ballot applications and submissions. So when they come in, you don't check them. You just presume they're valid. But also, this is a contest about rules that were promulgated by Jocelyn to assist local election officials in the signature verification process. Now, the court concludes here today that any presumption of validity cannot pass muster under Michigan law. And the rules promulgated by Jocelyn can withstand the challenge under Michigan law. So we're kind of splitting it. Now, here's some factual background. Now, this is why opinion is so important, is because it gives us some clarity on what happened in this year, 2020. What happened? Oh, the Secretary of State provided guidance to local election officials, this is the judge writing, that included a presumption of validity for voters' signatures. So when the signatures came in Michigan in 2020, they're just presumed valid. Isn't that fun? On absentee ballot applications and absentee ballots processed at the local level. Judge cites footnote 1. He says the formal term is absentee voter ballot, but we're just going to use this phrase for simplicity. Got it. Now, Plaintiff Michigan Republican Party and the Allegan County Clerk, they filed suit to bar the use of the presumption of validity in a guidance document. The Court of Claims ultimately determined the guidance was impermissible because it did not comport with the requirements set forth in the APA. And guess what? The opinion of the Court of Claims came out. Looks like it was issued March 9th, 2021. So now what we can surmise from this is that these orders came out. So let's just think about the timeline here. The order came out from Jocelyn Benson in 2020. You guys do it this way. Accept everything that comes in. Republicans sue. It's not until March 2021 that it's over. They say, oh yeah, March. Election's over, okay, in March 2021. So they start in 2020. They rig the election. They get told that you can't do that. So in March 2021, they go back to the drafting table. The decision in Janetsky says that they sent the defendants back to the drafting table. So after they rigged 2020, in July 2021, the Department of State initiated a process of rulemaking under the APA to promulgate signature verification standards for absentee ballots and absentee ballots applications. Okay, so they created this window and now they're fixing it. Now that effort yielded a set of rules for signature matching. That went into effect on December 19, 2022. So you see, they were doing whatever they wanted. There was a presumption of validity for all the signatures. It sounds like we can infer that from this in 2020. Just accept whatever you want. Then there's a lawsuit. They get sued. It gets reversed after the election. It's crazy. Those rules include a provision talking about entitlement, sufficient agreement of voter signature, initial presumption of validity. So they wrote back in 2022, they came back and wrote some new rules and they still shoved it in there. So they shoved initial presumption of validity back in the rules, even though it wasn't necessarily allowed from that prior opinion. So even though the catch line refers to an initial presumption of validity, so they put that in like the rule, okay, it's rule 2, and it's all of those things, voter contact, it's like the title of a chapter. The body of rule 2 makes no initial presumption, no mention of it. So it's just kind of in the title, but it's not in the actual rules. Now, how that came to be is a story itself. Judge is like, why'd they do that? Why'd they put it in the title if it's not in the actual rule? The initial draft of rule 2 after 2020 provided that signatures must be reviewed beginning with the presumption that the voter's signature is genuine and it's valid. So when you have all these fake ballots that come in, you can't even, it's presumed valid unless it looks like it's, you know, Mickey Mouse or something wrote it. Mickey Mouse's signature. It's like, okay, that's clearly not Mickey Mouse here, probably not, maybe. So during the public comment period, however, the negative response to the presumption was so strong that the Secretary of State accepted a proposal from another committee to strike the instruction that local election officials must begin review of a voter's signature on an absent voter ballot application or on absent voter ballot envelope with a presumption that the signature is valid. Now, perhaps due to an oversight because our legislators are so idiotic, the reference in the catch line to the initial presumption of validity remained in Rule 2, but the parties appear to agree that the catch line does not control the meaning of Rule 2, so its reference to, quote, an initial presumption of validity provides no legal authority for a presumption. Our government is so dumb, okay? Like, they have to go redraft the rule to get rid of this because the prior case told them to, and then they come back and it's still in there. They pass it. Nobody spell check this thing or proofread it? Significantly, the rules for signature matching under Michigan Code include 2 provisions. One is guidance on redeeming qualities of signatures. One is on explanations for differences in signatures. By all accounts, both of those rules remain in effect today. And additionally, the Secretary of State issued advice and guidance, that's Jocelyn, to local election officials again in December 2023. So now she's telling them how to conduct signature comparisons on these votes. That document is entitled Signature Verification, Voter Not Notification, and Signature Cure. It's now at the heart of the dispute. So then, just a couple months ago, in this year, a collection of plaintiffs filed this action against her again, seeking relief. In 5 counts, they asked the court to declare the guidance in the new December manual, as well as this new rule, invalid under the Michigan Constitution. Okay, Jocelyn is trying it again. And now, after extensive briefing by the competing parties, we had oral arguments, and here's what the court has decided. The defense wants this court, that's Jocelyn, to dismiss this, and the challengers want summary judgment. But here's what the courts say. First of all, there is standing. Now, although this action was violated by a constellation of plaintiffs, the standing issue appears to involve no factual dispute at all, so the court can resolve this based on the existing record. Now, one of the plaintiffs, Cindy, serves as the town clerk, and so she needs a ruling in the form of a declaratory judgment. So she has standing, and they didn't challenge her standing, so we're here. We can decide this case. Now, let's talk about the actual manual. The guidance manual issued by Jocelyn Benson in December of last year to try to rig 24 to, quote, a assist clerks in dealing with signature verification, voter notification, and signature cure, states, okay, Jocelyn's trying it again. So insane. She just got told don't do this. She just put it in her manual. Voter signatures are entitled to an initial presumption of validity, okay? So they just added it. It's not to a presumption of validity. It's an initial presumption of validity. They're such scammers. Jocelyn, we know what you're doing, cheater. You just can't add a word in there and solve the whole thing. The plaintiffs contend that an initial presumption of validity is also impermissible, and the court agrees. Golly. Under the Constitution, election officials, they say, shall verify the identity of a voter who applies for an absent voter ballot other than by in-person and by comparing the voter's signature with the record. You must do that. And you must verify, it doesn't say presume it's okay, and you must verify the identity of a voter who votes an absent ballot by comparing the signature against the record. And so thus our Constitution calls for a comparison. You have to compare it. You cannot just make a presumption for or against validity. Jocelyn, you actually have to look at the signatures. Okay, when people were saying in 2020 they weren't checking signatures, this is why. Because they weren't. Because Michigan, Jocelyn, were saying there was a presumption that they were valid. So you didn't even have to check. That was in violation of the Michigan Constitution. Constitution says you shall verify it. Our Constitution calls for it. The language in the Michigan statute also precludes the application of a presumption of validity. It says you must review. You shall. The city court shall review each absent voter ballot return envelope. And by verifying, you must verify the signature in accordance with the law. It makes no mention of a presumption of validity. That's what Jocelyn wants, so all the fake ballots can come through. They don't have to check them at all. Here's what else Michigan law says. An elector's signature is invalid only if it differs in significant and obvious respects. Slight dissimilarities must be resolved in favor of them. Exact signature matches are not required. It just has to agree sufficiently. Now, those three sentences, which do not prescribe or even suggest a presumption of validity, no, they provide election officials with directives they must follow in verifying the signatures on the absentee ballot and the applications and envelopes. You don't get to just decide that they're fine. In response to the challenger's reliance on this pellucid statutory language, so in response to the plaintiff's reliance upon the pellucid statutory language, which is obviously clear as hell, the defendants take the position that the guidance manual does not prescribe a presumption. No! Instead, it calls for a more modest initial presumption. With apologies to Gertrude Stein, says the judge, however, a presumption is a presumption is a presumption. Whether the guidance manual includes a gentle nudge instead of a hip check, okay, whether it's a love tap or a right cross, it's still foul under Michigan law. Jocelyn, you cheater. Initial. Preliminary. She'll come back, she'll call it a preliminary initial presumption. She'll call it a PIP. It's just preliminary. Indeed, the defendant's decision to initially assert but then to later withdraw the presumption language speaks volumes about their understanding of Michigan law. So we know you tried to put it in and then put it out and will not allow. And so accordingly, the court shall award a declaratory judgment describing as impermissible all presumption language, Jocelyn, contained in the guidance manual for dealing with absentee ballots. You don't just get to make up whatever you want. Now, they also concede that some of these other rules, the plaintiffs, the challengers, but they nonetheless assert some of these rules are valid, but some are not. Now, based on the court's analysis, the portion of the catch-all line in Rule 2 also must be excised. So delete that from your rule, Jocelyn. The excision of that language from the catch line will not have any appreciable effect because it's not part of the statute itself. So take it out of the rules. Rather, the catch line is inserted for the purpose of convenience. It's like chapter titles, but it's not in the chapter, so get it out of the title. The principle presumably applies with equal force to the rules. Now, the more difficult question concerns the validity of Rule 4, which is talking about the explanation for the differences in the signatures. So can you say that they match? You actually have to compare. Okay, you can't just say there's a presumption. But now, okay, we're comparing. Now can we decide that they match? Here are some 5 possible explanations where the election riggers can say, oh yeah, it matches totally, yeah, and then shove it through. So they'll say 1, evidence of trembling or shaking in the signature because you're getting old, health related, getting old. The voter may have used a diminutive of their full legal name. So if I write like Rob, but not Robert, or R Govea instead of Robert Govea, maybe that's good enough. The voter's signature style may have changed slightly over time. The signature may have been written in haste. The surface of the location may have been rough, even, or unstable. And that all sounds fine, right? Like, yeah, sure, our signatures are not exactly the same every time. But in separate language that is permissive, this other rule explains that other officials may also consider factors applicable to a particular voter. So now they can just look at the individual, not just the signature. Like the voter age, the age of the signatures. So how old is this person and when is the record? Like, is their signature record 5 years ago? Is it 25 years ago? The possibility the voters disabled their primary language, the quality of the digitized signature, and so on. Now, the court disagrees. They say, that sounds like you have that power. The Secretary of State possesses powers and duties about these procedures, and those rules are allowed. A signature is only invalid if it's inspected and slight dissimilarities seems like it's in alignment with those rules. So those rules are valid. Now, without question, it says, let's be generous to the voters. Allow for disqualification only if it's like clear. Slight dissimilarity should be resolved in favor of the voter. And so the judge says, we'll allow those rules to continue to be in place. But for all the reasons set forth, the court declares that Jocelyn's second attempt at initial presumption of validity of signatures is incompatible with the Constitution of Michigan. The court declares that the catch line, initial presumption of validity, which they tried to shoehorn in there, is also incompatible. Now, other things are compatible. You can consider reasons why they might match, even if they look like they might not. The court invites further proposed judgments here soon. Signed by Christopher P. Yates, Court of Claims from Michigan. And so Jocelyn Benson loses big time on that. You can tell this was pretty significant for them because of how hard they were trying to just even get the language in. If they could just even have it a part of the rules, then the people at the polling places would say, oh, no, but it says right here in the rules. It's not in the rule, but it says in the title, so I guess maybe we can presume they're valid. Then they changed it. They want the presumption so badly that they just changed it to call it an initial presumption to see if they could squeeze that through. Maybe they'll try preliminary initial presumption sometimes on Tuesdays. Maybe that one will fly through. Keep trying, Jocelyn. They're cheaters. They're liars. They're trying to rig 2024 just like they did in 2020, which is what they did in Michigan. So here's Jocelyn. She is out now. This was just a little campaign update from her. This is what Jocelyn's working on in Michigan. We're going to see what she sounds like as she unveils her new mobile secretary office.
Starting today, the Secretary of State Resources and Services will become a little more accessible. Secretary of State Jocelyn Benson joined various community leaders and officials on the steps of the Marquette District Court to celebrate the launch of the newest Secretary of State mobile office. With Michigan's Upper Peninsula being such an expansive region, the Secretary of State says having this resource will mean citizens who have difficulty getting to the nearest Secretary of State office will be able to access important resources much more easily.
Well, as Secretary of State, it's been really important to me to ensure, as someone who also has a home here in Marquette, that we effectively serve everyone throughout the state, whether they're in Copper Harbor or all the way, or in Houghton, or all the way down in Hillsdale or Grand Rapids or Detroit. And so this dedicated mobile office will serve residents of the Upper Peninsula all throughout the year and make sure that anytime they need state services, they'll be able to access them conveniently and effectively. We anticipate visiting senior centers, veteran shelters, community events, and other gatherings, and anyone can request a mobile office to visit their event facility at michigan.gov/SOSmobile.
It sounds like she's creating a little mobile ballot harvesting DoorDash operation or something like that. Do you need us to come pick up some ballots from you? Perfect. We have a mobile Secretary of State office. We'll be happy to come up and pick. Where's your printer at? Oh, I mean, where's your residence at? Great. We'll see you soon. All right. So Judge Christopher Yates puts the halt on the multiple attempts to create a presumption of validity. That is a nice catchphrase for us to remember anytime they say, well, how was the election rigged? You say, oh, it was easy. There was an illegal rule change in Michigan where she adjusted the mechanism by which signatures are supposed to be matched. She just said that they're all presumptively valid. There was a presumption of validity in her own rules, meaning they did not even check them. They just presume they're valid. And a court in Michigan has now confirmed that the attempt to do that again in 2024 is invalid. But none of that was addressed in 2020. Michigan was rigged, as we know. Now it's proven by a judge. So this is something we'll continue to cover. This election litigation is going to heat up here as 2024 emerges every single day closer and closer. And we're going to continue to cover it, my friends. So thank you for subscribing as we do. Would love it if you liked this video, and really would love it if you shared this content with a friend or family member, especially if they're in Michigan, so that they know what is going on. We'll see you on our next segment, which is where we're going to be talking about Fani Willis and her little meltdown there. People calling her Fanny, and she doesn't like it. So we'll see you there and back here on the next one.